The air was thick with expectation as the man in the navy suit moved to the podium in Courtroom 3 of the United States Supreme Court. He didn't seem anxious. He didn't have the bearing of a lifelong attorney. But there was something, a profound calmness in how he adjusted the microphone, met the gazes of the 9 most influential judges in the nation, and began, "Mr. Chief Justice, and may it please the court." That voice, and everyone present instantly recognized it, deep, resounding, and truly iconic. It was Denzel Washington. Indeed, that Denzel, the Hollywood giant, 2-time Academy Award victor, he of Malcolm X, Training Day, and The Equalizer fame. So what on earth was he doing here at the Supreme Court? And clad not for a glamorous event, but to contest legal principles before the country's most formidable tribunal. The courtroom, filled to the brim with law clerks, and journalists and seasoned lawyers, felt as though it had slipped into some strange, parallel reality. People murmured, some chuckled softly, and as this a publicity stunt, he's here to speak in a genuine case. But within moments the situation shifted. Chief Justice John Roberts, presiding from the high bench with his characteristic composed authority, leaned forward and interrupted less than a minute into Washington's initial remarks. "Misere," and Washington, Roberts said, his voice measured but sharp, "and I find it hard to believe that someone with your background fully comprehends the constitutional ramifications of your argument." It was a challenge veiled in condescension, and a statement that hung in the air like a spark ready to ignite something much bigger. The room became utterly silent. A law clerk glanced up from his laptop, and a federal prosecutor straightened her necktie. Even Justice Kagan raised an eyebrow, but Washington didn't waver. He didn't offer an apology. He didn't falter. He simply paused, raised a well-worn copy of the Constitution, and met the Chief Justice's intense gaze with the composure of a person who had spent his entire existence getting ready for such moments, just not in a court. "And, Chief Justice Roberts," he responded, "if I may, let's examine the text together." At that very moment, the energy in the room transformed. This wasn't some actor pretending to be a lawyer for the cameras. This was a person who knew the law, from page to page, case by case. Someone who had secretly earned his law degree, studying through the nights and on weekends at Howard Law, while still filming major motion pictures. And now he was standing here before the highest court in the land, arguing in a genuine constitutional case, Henderson v. DOJ, and a case that had the potential to redefine civil forfeiture in the United States. Initially, many presumed the court had given Washington a token speaking slot, maybe just 10 minutes to appear inclusive, perhaps even media-friendly. But when he began to cite case law from the nation's founding period, and quoting James Madison's letters and referencing legal doctrines that most lawyers hadn't reviewed since law school, people started to pay close attention. Even the Chief Justice leaned back in his chair, as if reconsidering everything he had just uttered, and what had begun as an odd celebrity guest appearance was evolving into something else entirely, a direct confrontation, a legal reckoning, and possibly the start of a monumental shift in American constitutional interpretation. Washington wasn't merely fighting for the legal theory in his brief, and he was contending against every assumption in that room. The idea that a film star cannot be a legal scholar, that preparation doesn't matter when fame is involved, and that some voices simply don't belong in the nation's most revered legal chambers. But in just 5 minutes, Denzel had completely shattered that illusion, and he wasn't even close to being done. In the next part, the comeback that silenced the chief, where Denzel flips the courtroom with a single case from 1827. Don't miss it. Chief Justice Roberts didn't back down. If anything, he leaned in closer. "Mr. Washington," he declared, "and your brief indicates that civil forfeiture was historically limited to maritime and customs cases. But have you overlooked the Palmyra from 1827? That ruling expanded the government's forfeiture authority without requiring criminal convictions. It was a trap, subtle but perfectly precise legal bait. And most courtroom veterans had seen this tactic before. Roberts was testing him with a historical precedent that had tripped up even highly experienced litigators. And miss a fine point, misstate a detail, and the entire argument could fall apart. But Washington didn't even flinch. He turned a single page in his folder, just one, and then looked up and responded without any hesitation. "Chief Justice, I value the reference. In fact, and the Palmer is examined in great detail on page 23 of my brief." He paused, his eyes calm, his voice steady. While that case did permit forfeiture without a criminal conviction, it did so strictly within the framework of maritime law, specifically piracy, and Justice Story wrote that the vessel which commits the aggression is treated as the offender itself. It was a legal fiction, not a constitutional norm. He lifted his hand, and 3 fingers extended. That principle was applied when personal jurisdiction over pirates couldn't be established. But applying that same fiction to innocent American property owners in modern-day Philadelphia is a constitutional stretch. And the framers never intended this. The room became completely still. Even Justice Alito looked up from his notes. Washington wasn't just winging it, and he had mastered the original case law, not just quoting the Palmyra, but interpreting it better than many law professors ever had. And then came the moment that transformed whispers into a collective stunned silence. He went on, and I have examined every civil forfeiture case decided by this court from 1789 to 1850. All 27 of them, every single one involves either piracy, customs violations, and/or maritime seizures. Not a single one sanctioned the kind of domestic, land-based seizure at issue in Henderson. Not one. He didn't require slides. He didn't need a legal team whispering in his ear. He didn't even look at his notes again. Just decades of legal history memorized, organized, and presented with a clarity that made people forget who he was until they suddenly remembered. Justice Kagan leaned forward. Justice Thomas, famously quiet, nodded ever so slightly, and in that moment everyone in the chamber understood. This was not a Hollywood act. This was a man who had studied the Constitution as if it were a script that could still alter lives. A man educating America's highest court about its own past. It was more than a comeback. It was a courtroom checkmate. The game had just begun. In the next part, the moment the justices took him seriously, when Alito, Barrett, and even Kavanaugh step into Denzel's legal arena. What happens when the courtroom stops laughing and starts really listening? When a person they believed was just a celebrity turns out to be the most prepared individual in the room, and you are about to witness the precise moment the Supreme Court justices on that bench realized Denzel Washington wasn't just here for a headline. And he arrived with the receipts, the history, the law. And in this portion of the narrative, the courtroom dynamic completely flips. And the silence that followed Washington's historical takedown of the Palmyra was not awkward. It was full of respect. For the first time that morning, and nobody doubted he belonged there, but Denzel did not pause for applause. He moved forward, building momentum like a seasoned litigator. Justice Samuel Alito, often aligned with law enforcement interests, broke the quiet. That's an interesting historical observation, Mr. Washington, he said. But how do you reconcile that with a more recent precedent in Bennis v. Michigan? This court upheld the forfeiture of a car from an innocent owner. That's not 1827, and that's modern law, another trap, a difficult one. Washington did not hesitate. Justice Alito, Bennis was wrongly decided. A soft gasp spread through the courtroom, and calling out a bad precedent, especially a Supreme Court one, was a move most attorneys avoided unless they had an absolutely solid backup. But Denzel was ready. And I'm not the only one with that view. Justice Thomas, joined by Justice Ginsburg, justices with vastly different judicial philosophies, both dissented in Bennis. They recognized that seizing property from an innocent spouse without any connection to wrongdoing strains the Constitution's protections. He turned a page in his notes, and then looked up, and since Bennis this court has shifted. In Austin v. United States, and the court acknowledged that civil forfeiture is quasi-criminal subject to the excessive fines clause. Then in Timms v. Indiana, and the court held that these protections apply to state governments, too. Washington's delivery was sharp but never arrogant. He wasn't scolding, and he was providing an education. Justice Brett Kavanaugh leaned in. Your historical argument is convincing, Mr. Washington, he said. But let's talk about the practicalities. Civil forfeiture is a crucial tool for law enforcement. Are you suggesting we should get rid of it entirely? A reasonable concern, the kind that carried weight across ideological lines. Washington nodded respectfully. Not eliminate, Your Honor. Reform. He raised one hand, steady and clear. I am suggesting this court reinstate civil forfeiture to its original limits, appropriate for maritime cases and customs enforcement. And when the government cannot establish jurisdiction over the property owner, his voice became softer, drawing the room in closer. But when the government can prosecute and chooses not to, yet still seizes property without a conviction or due process, we have crossed a constitutional line. And that is what happened in Henderson, and that is what the framers cautioned us about. by now, and even the justices who had initially raised eyebrows were listening with extreme care. Justice Amy Coney Barrett entered the conversation with curiosity, not a challenge. Mr. Washington, she said, your brief includes an interesting argument about how the Due Process Clause and the Takings Clause work together. I don't recall seeing that theory presented quite that way before. Could you elaborate? Washington offered a slight smile. This was the specific path he had created for himself. Thank you, Justice Barrett. Yes. While those clauses are typically treated separately, Madison himself, and who drafted them, saw property rights as deeply connected with procedural protections. He took out a copy of a handwritten letter. This is a letter from Madison to Jefferson in 1788. It has not been cited in previous civil forfeiture cases, but in it, Madison writes that the arbitrary seizure of land without process or a public purpose is a double violation, both against justice and against ordered liberty. A moment of genuine admiration passed through the room. Justice Clarence Thomas, who rarely speaks during oral arguments, and glanced at the document. Slowly he nodded. The shift was now complete. 10 minutes earlier, some in that chamber thought Denzel Washington was there for a show. Now, and he was the standard by which their own arguments would be judged, and he wasn't done yet. This court, he stated, has an opportunity not just to correct one wrongful seizure, but to reset the constitutional boundaries that have slowly eroded over decades. We can honor the text, and the history and the people this Constitution was written to protect. He paused. No dramatic music, no cameras flashing, just 9 of the most powerful legal minds in the country, silent, focused, and changed. Next episode, Robert's Respect, the turning point, when the Chief Justice stops testing and starts genuinely listening. 6 weeks after the oral argument, the nation held its collective breath. Legal scholars offered theories, the media buzzed, social media was ablaze with speculation, but no one, absolutely no one, expected what happened next, and the Supreme Court ruled 7-2 in favor of the petitioners in Henderson v. Department of Justice, and in the majority opinion, and the court embraced nearly every part of Denzel Washington's proposed constitutional framework. Chief Justice John Roberts didn't just vote with the majority, he wrote the opinion. After a careful review of constitutional history, the opinion read, and we conclude that civil forfeiture, as it is currently practiced, extends far beyond the boundaries intended by the framers, and property may not be taken from innocent owners without a demonstrated connection to wrongdoing, due process, and a public use that serves more than just revenue. 4 separate times, Roberts quoted from Washington's oral argument, his very words now immortalized in U.S. and constitutional law in a striking footnote, and the opinion commended amicus counsel for exceptional historical research and doctrinal clarity. That counsel was Denzel Washington. For the very first time in the court's history, a man outside the legal establishment had successfully reshaped its understanding of property rights. Within 48 hours, and the ripple effects began, 5 states announced immediate reviews of their civil forfeiture statutes, and millions of dollars in property was returned to community organizations, churches, small business owners, people who had never been charged with a crime, and federal agencies started restricting seizures to cases with criminal convictions or clear evidence of owner involvement. Justice Sonia Sotomayor's concurring opinion struck a deeper chord. Our Constitution must not allow the government to dispossess the voiceless with impunity, and the numbers presented by Mr. Washington speak volumes. It is the poor, the marginalized, and the overlooked who suffer most from unchecked power. But perhaps the greatest influence came beyond the law books. Social media exploded. Hand Denzel for Justice, and Phi Constitutional Washington. Phi headed the homework. Clips from the oral argument accumulated millions of views. College students, public defenders, and professors began quoting Denzel not from his movies, but from his footnotes. 3 days later, Washington released a quiet statement, and the Constitution belongs to the people. I'm grateful the court listened. But he didn't stop there. Washington launched the Washington Justice Initiative, and a non-profit organization dedicated to defending victims of unlawful property seizures and training young attorneys to seek justice with historical accuracy. Within weeks, and law schools invited him to guest lecture. News outlets called it one of the most surprising and significant Supreme Court moments of the decade. But for the communities that got their homes, businesses, and dignity back, it was more than just important. It was deeply personal. And it all began because one man, unanticipated, underestimated, and completely prepared, stood up and spoke the truth in a room that was never built for him. And next episode, Legacy Beyond Fame. What Denzel does next and what his courtroom moment signifies for the next generation of justice seekers. It had been 6 months since the Supreme Court's decision in Henderson v. Department of Justice, but the aftershocks were still being felt in law schools, courtrooms, and in communities all across the country. And yet, Denzel Washington was nowhere near a red carpet. Instead, he was standing in front of a whiteboard at Howard University School of Law, speaking to a packed room of first-year students. The topic: the original meaning of the Fifth Amendment's takings clause. There were no film crews, no fanfare, just a legal mind sharing everything he had absorbed with the same quiet intensity that had once held the attention of 9 Supreme Court justices. Later that week, he shared a stage with none other than Chief Justice John Roberts at a civic education forum at Georgetown Law. The topic: bias, perception, and the unexpected messengers of truth. It was a moment few could have foreseen just months earlier. Roberts, and once skeptical, some said dismissive, of Washington's right to even be in the courtroom, now sat beside him as a colleague in legal thought. And what Denzel reminded all of us, Roberts said candidly, is that brilliance doesn't always wear a traditional uniform. The law doesn't care where you came from, and it only cares whether you did the work. Washington, true to form, didn't linger on personal praise. This was never about proving I belonged, he said. It was about proving the Constitution belongs to everyone. From fame to foundation, the Washington Justice Initiative quickly became a force for good, and funding legal clinics in underserved areas, building a fellowship for minority students in constitutional law, and offering direct legal aid in civil forfeiture cases. Law students across the nation began citing his oral argument in their papers. Professors redesigned their syllabi to include the Henderson case, but most impactful of all were the letters from high school students in Detroit, from veterans in Houston, and from a grandmother in Georgia who had her home returned after a wrongful seizure. "You made me believe," one letter read, "that justice still listens if someone has the courage to speak." The message beneath the story in the end. And this story was never just about a Hollywood actor who learned the law. It was about redefining what authority looks like. It was about uncovering bias even in the highest chambers of justice. About how preparation, when combined with purpose, can dismantle even the most rigid assumptions. And Denzel Washington didn't achieve a win because he was famous. He won because he was prepared. He won because he studied harder than anyone could have expected. And because he respected the law more than the system had respected him. And because he believed in truth even when no one believed in him. The final thought: years from now, and students will still read Henderson v. DOJ, they will still analyze Washington's 3-part test, and they will still ask, "Wait, you mean the Denzel Washington, and that Denzel Washington?" And their professor might smile and say, "Yes," but by the end of that argument, he wasn't an actor anymore. He was a constitutional voice, and a reminder that the law belongs to all of us. So remember this: never underestimate someone who takes an unconventional path. Because sometimes the most powerful arguments come from the most unexpected places. And thank you for following this truly unforgettable journey. If you were moved by this story, by its message of justice, humility, and perseverance, and please consider sharing this video. Leave a comment below about what equal justice means to you. And don't forget to subscribe for more powerful stories where truth finds its way to the top, even when facing all odds.